Morning, everyone. Welcome to Ask the Expert, an award-winning daily series from 8:30 a.m. to 9 a.m. to help small businesses. If you've got any questions, you can ask them in the comments of the live feed, and I'll deal with them as we go along. If you need any more advice, join the official Intuit QuickBooks SMB community group on Facebook. Accountants and business experts are on hand 24/7. During the live session, we'll be running a poll, so please do engage with it, and I'll reveal the results at the end. So I'm the founder and CEO of LawBite. LawBite is a law tech enterprise. We provide a marketplace, democratizing the law for SMEs. So we link expert lawyers with SMEs through our technology platform. And the purpose is to provide law that is fast, affordable, and easy to use, rather than slow, expensive, and complicated, which is what many SMEs are used to. So through our platform, you can get everything you need from startup to exit. We have over 60 lawyers on hand through our own regulated law firm, and you can easily contact us through live chats or on the phone, or simply by filling in a form, which is very easy to fill in at lawbite.co.uk. We've dealt with over 40,000 SME inquiries. We know a lot of the things that have troubled you and will no doubt be troubling you now. We've helped SMEs, thousands of SMEs during COVID with all sorts of issues that came up as a result of that. So I'm sure we can help you if you need help. Either go to the website, engage in live chat, fill in a form, or call us on 0207 148 1066. You get a free chat with a lawyer. We provide that to all people who make an inquiry at the site, so you don't have to feel the meters running the minute you get in touch with us. So I hope that's helpful, and we look forward to seeing you at LawBite in due course. So we're here today to talk a bit about IR35, and I know IR35 has created lots of concern and confusion for many SMEs who provide their services as contractors. So I'm just going to today talk a bit about the kind of problems that are arising, and maybe give you some tips as to how to mitigate or even avoid those problems. So what is IR35? IR35 is an Hmrc directive, and what it's trying to do is prevent contractors sidestepping their status as an employee by using a personal service company as a vehicle for their contractor services. Many individuals provide services through their own companies in order to avoid being classified as an employee. This enables them to pay lower taxes, as they don't have to pay employee national insurance if they're not an employee, and it's equally often good for their client, because the client using their services as a contractor doesn't have to pay employer national insurance, currently running at 13.8%. For employers, it also avoids them having to give the kinds of benefit available automatically to employees, for example, paid holiday. So the government feels that this device has deprived them of millions of pounds of tax, when in fact the contractor is so closely aligned with the client that really the individual was just an employee in disguise, even though they used a personal service company to provide their services. So there's a well publicised example involving Gary Lineker providing his services to BBC through a personal service company. Was he an employee or not? So what's changed then? So previously, the service company decided whether the individual was a contractor. And so that was a pretty self-serving mechanism. So most contractors didn't ask themselves too many difficult questions and just declared themselves as contractors. As of 6 April 2021, This decision is now made by the client instead, by way of what's called a status determination, which they then have to share with the service provider. So the government decided to flip that decision-making process because it felt that the client companies, who might have many contractors, were easier to investigate than individual service companies, and also they felt perhaps that big client companies, being a bit more risk averse, were more likely to be compliant and decide what Hmrc wanted, which is that contractors were really employees. So if the status determination is that the contractor is really an employee, then the client must deduct the applicable taxes and pay Hmrc as though the contractor was an employee on the payroll. If they don't do that, then they could be hit with a tax bill retrospectively by Hmrc and also penalties. So how has this all been working out? So many big client companies can't be bothered to do individual sort of nuanced assessments of the status of each contractor, although they are supposed to do just that. So what they're doing is they're just deeming that all their contractors are now employees. This creates a big tax hit for many contractors, and they're often told that there's no budget available to raise their fees to compensate for the increase in tax, so they end up worse off. Alternatively, bigger client companies are putting an embargo on dealing with contractors at all, and as a result, many contractors are finding there are less opportunities to work as a contractor, and they're giving up their contractor status and doing other things instead. One contribution to the current staff shortages that we all keep reading about in the press, especially in sectors which previously used a lot of contractors, is exactly this change in status. And contractors saying, well, I'm not going to bother with this anymore, it's too complicated, I'm no better off than if I was an employee, I'm not going to be a contractor anymore. So sectors which used a lot of contractors, like HGV lorry drivers, for example, that's contributing to the staff shortages. So what can contractors do about all this? Well, first of all, there are a number of factors which are supposed to be taken into account when deciding whether someone is a contractor. They're on an online list called CEST for short, Check Employment Status for Tax, CEST, and you can find that service online. And you should certainly make sure that as a minimum, you fit the criteria under CEST for being deemed a contractor rather than employee. It's a very simple test. The tool asks you lots of questions, and depending on your answers, it tells you whether or not you are an employee or a contractor. So factors which are relevant, which lean one way or the other, are you allowed to provide a substitute for your services? So if you are allowed to provide a services, that tends to suggest you're more of a contractor than an employee, who obviously is the person employed to do the job. How much control do you have over the way your services are provided? So if you have lots of control, then you may more likely be a contractor than an employee. How much supervision and direction is there over your services? So if the client actually has a lot of supervision and direction over what you do, how you do it, you report to a designated employee, then you're more likely to be deemed an employee. How much financial risk do you take? For example, can you claim for expenses? Do you have to pay yourself to remedy things if you get them wrong? Financial independence indicates you're more likely to be a contractor than an employee. Is the client obliged to offer you work, and are you obliged to accept it? So is this just a contract, for example, for a one-off project, or is it ongoing? If you're an employee, you don't really have any choice about doing the work your employer tells you to do. If that's the case in your contractor arrangements, then you're probably an employee and not a contractor. How are you paid? e.g. employees are often paid monthly, but contractors are more frequently paid in stages or at the end of a project. So that's another clue as to your true status. Are you exclusive to the client? If you can't work for others at the same time, then you're probably going to be deemed an employee of that particular client. Do you get employee benefits like holiday pay or pension or other perks? If so, you're more likely to be deemed an employee. Are you what's called part and parcel of the client's business? Are you, for example, subject to their staff handbook and their policies? All of that would suggest you're more likely to be deemed an employee. Do you provide your own equipment? For example, do you provide your own laptop? If so, you're more likely to be deemed a contractor. And where's the work carried out? So perhaps more of a relevant test pre-COVID, but if you carry out work on premises for the client, then that's a factor that might indicate that you're more likely to be an employee. So this test is very useful and can tell you whether you are likely to be deemed an employee or contractor. And obviously, a way of making sure you get the test answered the right way is to make sure that in your contract for your services, you're dealing with these issues in such a way that if your contract was produced as evidence of your status, it would support all these factors I've just run through, which suggest that you are a contractor rather than an employee. So all that's a good way of trying to take yourself out of IR35 if you can. The second thing you can do is to check whether your client is exempt from providing a status determination. So the government recognises that it's creating a lot of extra red tape for clients by introducing this rule change. And so it's produced some exemptions. And if your client's fairly small, it may well be that the old rules apply. And so it's still up to you as a contractor to decide your own status, which is obviously where you want to be. So there are exempted clients if they fit one of the following criteria. So their actual turnover is no more than £10.2 million. Their balance sheet shows no more than £5.1 million worth of assets, or they have no more than 50 employees. So most SMEs would fall into that bracket, even if they're engaging contractors. So do check with your client whether they are part of those exemptions, because that may take you out of the new regime altogether. And the government's created an obligation on the clients to tell you about their those factors that I just mentioned. So if you want to ask, they're not allowed to say to you, well, I'm not going to tell you that. So you can check with your prospective client whether or not they're exempt, and if so, the old rules still apply, and you can decide yourself, self-declare whether you are a contractor or not. The third thing you can do is check that the right entity is giving the status determination. So supply chains are often more complicated than the government allowed in the in its IR35 legislation. So many times contractors provide work through, for example, an agency, and it's the agency that then bundles up the services perhaps of multiple contractors and delivers them to the end client. So it may be that the agency company is really the client, depending on the circumstances of the case, and they may or may not have a more sympathetic approach to classification than an end user client. This area is not straightforward because the government's not provided very clear guidance, but broadly speaking, if the agency is the contracting party with the client, and or your services are more aligned with their business than the end clients, and or the agency is providing other services to the client as well as your services, for example, it might be providing materials or products or quality controls, then it may well be the agency which is deemed the client responsible for the determination and for making any payments. So this is not a straightforward process to check out, but it's worth checking it out because it may mean that it's not the end client who's actually making the determination, and you may get a more favourable determination as a result. Fourth thing you can do if you don't like the status determination is you can appeal it. You have a right by law to contest the status that someone gives you. So if you feel that the client is just making a blanket determination and not bothering to investigate the facts of your case, you can appeal it, and the client must respond to you within 45 days. So you may be able to persuade them to change your determination, particularly if you can show them that actually lots of those factors in the CEST test that I've mentioned earlier, the CEST test, are in your favour, and that really you should be deemed a contractor, not an employee. Now I'm not sure how often that appeals process is being taken up or working. I can see many contractors being a bit concerned about potentially annoying their end client by appealing, and the end client being a bit stubborn about not wanting to change the determination after they've decided it, but it is still a right that's open to you. And the other thing you can do is to provide your services through an overseas company. So if you provide your services through an overseas company, then you are exempt from the IR35 rules. Obviously, that may open up a whole bundle of other issues for you. It's not practical for everybody to create an overseas vehicle for their services, and also that might create different kinds of tax liability for you in the jurisdiction where your new service company is located. So can see that not being an obvious answer for everybody, but it is an answer. So so there you have it. There's a brief description of some of the problems with the new IR35 rules, and potentially some methods of mitigating against them. Anecdotal evidence is that at LawBite is that IR35 is creating a lot of problems for contractors, a lot of confusion and uncertainty. So we have employment contractor lawyer specialists on hand on the platform. If you want a free chat with one of them, you're welcome to contact us, and we can set that up. We normally manage to get a lawyer in front of you within 2 hours of your inquiry. So I hope that's helpful to you. I'm here to answer any questions, and if I can answer them today, I will. And if I can't, then I'll either suggest you contact me offline later, or defer them if they're too technical. So among the questions here, one on Twitter: do you have any recommendations for driving efficiency within an in-house legal team? Okay, so before I ran LawBite, I ran in-house legal teams for big companies like Warner and Sony and Bertelsmann. So I was used to running teams of up to 30 lawyers. I think efficiencies in-house very useful to the way you would run any job, really. Run things in a transparent way with your team, so that you've got very clear guidelines about particular ways you want them to tackle particular roles and particular types of problem. Very important that in-house legal teams are not perceived as the enemy by the kind of sponsors within the business. So I always encourage my legal teams to really understand the commercial issues of the business, and not just give legalistic answers. So if the in-house commercial team just wanted a legalistic answer, they could go and get it from an out-house lawyer. So there's no use saying to them, well, the law says either X applies or Z, but it's up to you to decide. That's not very helpful to an in-house company colleague. What they want you to tell them is, well, the law says this or that applies. My recommendation is we do this for the following reasons. And that's a more effective way to provide the service. And the third thing to remember as an in-house lawyer is that you're there to be a conscience for the company, to make sure they comply with the law, but you're not there to tell them what to do. So ultimately, many in-house decisions which involve law are a question of commercial judgment. And so I always encourage my lawyers not to make that judgment on behalf of the commercial colleague and tell them, you can't do this, because that's a sure way of creating disharmony with the commercial colleagues. And what you want above all is that they feel free and want to come to you with their problems rather than seeing you as an obstacle and avoiding you. Right. Next question from Facebook Messenger. I actually lost a client a while back because I was classed as inside IR35. The business couldn't afford to keep me on at my usual rates and paid additional taxes. I just got on with it and found a new role at the time, but looking back, should I have fought it? What rights do I have in this situation? Well, I think we touched on this, didn't we, during our chat? So unfortunately, there isn't a legal right to require the client to pay you more just because you're suffering a hit in tax as a result of the new rules. That, of course, is exactly what the government wanted. It wanted to collect more tax. So it is a matter of discussion with your client company, whether there are other ways they can help you, beyond paying you more. Maybe they can extend their commitment to you, give you more projects to do, extend the duration of a current project. But you can't actually force them to pay you more. So ultimately, the best ways around it are to prove to them that you are definitely a contractor by going through that list of examples I mentioned on the CEST test, and proving irreversibly that you're a contractor, or you can appeal it. But ultimately, this does create commercial issues for contractors if the client just won't play ball. I think that is the situation. Can IR35 be backdated? As in, is it likely Hmrc could claim I owe taxes from previous years? Yeah, it's a good question. The Inner Revenue's indicated that it won't do back investigations, even if under the new regime it finds that you've been given the wrong status determination and you should have been an employee. It won't go back to previous years in order to investigate those. So it's just an ongoing thing, and Hmrc has indicated it will be lenient in its investigations during at least the first year of operation of the new rules. So you've got a shot at not having a problem retrospectively and not getting in too much trouble during the first year if you get it wrong. I think beyond April 22, if you get it wrong, Hmrc will be less lenient, especially if it feels that you or the client company have sort of connived at getting to the wrong result in your status determination. And then an Instagram question here. As a freelancer and company director, what could I be doing to make sure I'm never inside IR35? Do I just have to keep having short jobs and multiple clients? Well, I think those are examples of things that take you into the contractor side of the determination rather than employee. Other things we talked about a bit earlier, avoiding looking like you're an employee because you're being paid as part of a salary run, or you get paid holidays, or you're subject to the staff handbook in the disciplinary procedure, or they provide you with all your own equipment, or you can't provide a substitute. It's just all about you and no one else other than you. All those things, if you can tick those boxes in terms of the contractor status, then you're better off. You're minimising the risk that the client company decides that you are definitely an employee after all. What does IR35 mean for company contracts with salary grades? Will they have to match that according to scheme rates or something else? That's another Instagram question. So if I might not have understood the question, but I think what you're saying is, if your rate of pay is determined by existing salary grades within your client company, what does that do to your IR35 status? Well, if that's the question, then the more you're linked to the client in terms of their policies and procedures, the more you look like an employee. So if your pay is set by reference to salary grades of other employees, then that would be a kind of flashing red light that you look more like an employee. Okay, and finally, I have my own limited company, but started working under an umbrella company because of IR35. I've noticed I've been paying for employer NIC on my last few pay slips. Is that correct? Well, you shouldn't be paying for employer NIC. You might be paying for employee national insurance contributions. So if in spite of you working for an umbrella company, the designation is still that you are effectively an employee. So I'd take that up with your umbrella company and check whether they're applying the rules correctly. Okay, and has the change? I've got the poll results now, and the question was, has the change in IR35 rules left you better or worse off? So I'm not surprised to see that 0% of you said it had left you better off. Unfortunately, it's not designed to leave you better off. It's designed for the government to get more tax. 30% of you said that you felt it had left you worse off. 70% of you answered, I don't really know. And I think that's quite telling as well, because as I said earlier, I think the rules have created a lot of confusion, and so a lot of people don't really understand whether they fall in IR35 or not, and lots of clients, companies engaging you, don't understand new rules either. So I'm not surprised there's quite a lot of ignorance out of there. I think it would be sensible to get yourself familiar with the new setup. Certainly by April 22, you should be doing it already. But by April 22, 1 year after it started, if you're not doing things the right way, then you're open to some risk if Hmrc investigates either your client company or you. So I think that's all we have to do this morning. So thank you all very much for tuning in. If you want to get in touch, you can send me an email at clive@lawbite.co.uk. To find out more about LawBite, you can visit our website, www.lawbite.co.uk. As I said, you can fill in a simple inquiry form engage in live chat. You can also call us on 0207 148 1066 and get your free conversation with an expert lawyer. So coming up on Ask the Expert on Monday is founder and managing director of Morgan Reach Accountants, Dr. Cameron Shake. So tune in to get some great advice on accounting and the latest features and tools that will make your bookkeeping easier. A reminder that if you need any more advice, you can join the official Intuit QuickBooks SME community group on Facebook, and accountants and business experts are on hand 24/7 to help you. I've really enjoyed answering your questions this morning, as always. Have a great day. Hope to see you again soon. Thank you.